Yes. Hello, my beautiful friends. What an amazing day it is. Welcome back. We have a great stream planned ahead. We got a bunch of news to attend to. Quick preview, then we'll jump into it. But a big response from the Trump DOJ. You can see one response, two cases. Big one from Lindsay Halligan out of the Eastern District of Virginia. Of course, we're talking about James Comey and Letitia James, both of whom are being prosecuted out of this district. And so this is about the battle over Lindsay Halligan. You remember we were covering the Trump prosecution brought by illegitimate Jack Smith, and we found out he's not a real boy, not even lawfully appointed or prosecuting the president. And he got disqualified, which caused some big problems for their case against the president. Now, Letitia and Comey are trying to do the same, to disqualify Lindsay Halligan, and Halligan has responded. And it's a big one, 32 pages, lots of technical stuff going on inside about the interim appointees, acting, and all of the statutes are all cobbled together, but we'll make some sense of it coming up. And then we'll talk about the judges who were responsible for a lot of those very prosecutions that Comey and Letitia were a part of. Of course, we're talking about Judge James Boasberg, this guy right here, appointed by Obama some time ago. Well, lots of calls here for more investigations into him. And we're also learning that they, according to Pam Bondi, we've already heard some of this from the Senate, but Bondi is now saying from her seat as the United States Attorney General, she can now confirm that Trump's phone records were also seized by Jack Smith. And not just Trump. We also have Kash Patel, and his records got seized, courtesy of Jack Smith. So we'll go through the latest on this. Jim Jordan is opening up a probe, and we got a Jim Jordan letter here. You know how much we love those. How long is this one? Oh, it's only 2 pages. Jim. All right, so we're going to go through that. We're going to see what Jim had to say about it. We got reactions from Jim Jordan himself, Judiciary Committee over in the House. Rick Scott, Senator, is now demanding more answers from Verizon, and we'll get on to all into the goodies. Before we wrap it up with our favorite thing, articles of impeachment against Judge Jeb Boasberg. And so we'll read through all of them. 4 pages here, courtesy of a representative called Brandon Gill, and go through some more reaction on this because the judges are out of control and there needs to be repercussions for their misbehavior. And now Grassley and Jim Jordan have also sent a letter to the Chief Justice of the United States of America, Judge John Roberts, over at the Supreme Court saying, John, you got to get a handle on these judges. Remember, we covered a case some time ago where apparently the New York Times was reaching out to hundreds of judges, more than 400 of them. And a bunch of the judges came out and started running their mouths about the Supreme Court. And they said, the Supreme Court doesn't have our back. Remember that? We're like, oh my gosh, these judges should be ashamed of themselves. Now Congress is finally looking into it a couple months later, but we'll go through it. We'll hear from Chuck Grassley himself, and we're going to have a great stream, my friend. So I hope your week was just amazing, and you're waking up from the communist hangover that we're going to be enduring in various locations around the country. We talked about that this morning on our members only stream. I think the takeaway, the silver lining is we're getting it out now. Let's all get this out of the system here so we don't have to learn the lessons after the midterms next year. Would rather have some difficulties on these elections so we can reconfigure what the party's doing and get things on a winning track the next season. So we talked about that this morning. We also talked about some of the trade tariff battling that was happening in the Supreme Court today. We were going to get into that, but I don't think it's quite as historic as many people are saying. It could go either way based on what we heard today. I know the poly markets were going down on the tariff thing, but we even heard from the plaintiffs themselves today who brought the lawsuit. They said, well, if Trump loses this, then he can just find other statutes to rely on and just reinvoke the tariffs using different powers. They were just unhappy with the one key provision that he was referencing. And so ultimately, all right, we'll see what the Supreme Court says, but maybe Trump just issues new ones under the new terms right now. I mean, we'll see what happens. So we talked a little bit about that this morning on our members only stream. We'd love to have you join us as a membo. Great way to support our work. Great way to meet other people. And I think we even might have a romantic relationship that is blossoming out there. which is very nice. One of the benefits of joining our community. So thanks for doing that. Thanks for subscribing if you haven't already. And now let's get into the business on the day, because we got some good stuff here. Starting in Virginia, Trump's DOJ now responding in 2 cases, with one filing, and it's a big one, against James B. Comey, former director of the FBI, and Letitia James, who are both being prosecuted by the one person we know as Lindsay Halligan. And she was appointed now as the interim U.S. attorney for this jurisdiction. And the defendants, Comey and Letitia, they're saying she's not properly appointed. She's like Jack Smith. She's not a real boy. And she needs to be disqualified. And Letitia wants the whole case to be dismissed, saying the prosecutor who brought it, who created the grand jury and that led to the indictment, was all tainted for whatever reason, and the case needs to go bye-bye. And so now what we see is Lindsay Halligan, if she is disqualified, that's going to throw a real wrench into the Trump DOJ case against 2 very important people, James Comey and Letitia, who in our opinion are both criminals. Now we'll go through this document. There's a lot of technical legalese inside, but we want to parse out the juicy bits, and we'll do that right now. But it's a big one, and it's in 2 cases because they're both making essentially the same argument, that Lindsay Halligan cannot be a part of this. And remember, Lindsay is a hero. She was the one who actually got appointed, fired some other people, and brought these cases forward before the statute of limitations expired, which were coming up very soon, especially in the Comey case. We were like 5 days away from not being able to charge him for his very obvious lies. And we spent all day yesterday reading through the many lies that we believe that he committed, not only to Congress, but to many other people as well when he was on his cable shows and writing his little, book reports and all the things, his little novels. He's a novelist or something. And so he is now under fire. Letitia's doing the same thing. So this is a desperate attempt to deviate the case at the very beginning. Now, here is what Lindsay Halligan says in response. All right. We're now responding in 2 cases, the Comey case and the Letitia James case. They say that they want their indictments, the whole case, dismissed. They say Lindsay Halligan was improperly appointed. They're saying she's not a real boy. Now, because Comey and Letitia's arguments are basically the same, just like them, this court has consolidated the motions for argument, and we're consolidating our response. And so we're going to respond squarely to Comey, who filed a motion to dismiss. He's saying the same thing. Selective and vindictive prosecution, although we obliterated that yesterday, taking a look at Comey's emails back and forth to the Columbia law professor called Daniel Richman, who's like, this is pretty fun. I'm doing a great job. Yeah. And they were colluding to leak materials to the media. Now, all of this, of course, is pending before the judges. And this is technically, I believe, in the Letitia James case. It's really both of them, but here we're trying to see how they're framing it. So and it's the same argument for both cases. Now, we'll fast forward through the table of contents, and here we go. Lindsay Halligan and her people say, all right, Judge, listen. Although Letitia and Comey, although they framed their arguments in constitutional terms, everyone agrees that U.S. attorneys are inferior officers whose appointment the Constitution permits Congress to vest by law in a head of a department like the Attorney General. Okay, everybody agrees on this. We're looking at the Constitution, Article 2, Section 2, Clause 2. What are the difference between inferior officers and regular officers? They're going to explain. Now, all further inquiries agree that Congress in the statute, so we're following the bouncing ball from the Constitution to U.S. Code, they did, in fact, vest this. The Attorney General has the power to appoint U.S. attorneys for at least 120 days. Now, the sole question in this issue is whether this provision of the law, 546, authorized Pam Bondi to appoint Lindsay Halligan here, where a previous interim U.S. attorney vacated office after serving 120 days and being reappointed by the district court. They say the law by Congress gives us the power to do exactly what we're doing, unlike the Jack Smith case, where they cobbled together, if you look at his appointment order, a bunch of different statutory provisions that said that they could create a special counsel. We cobbled those together. They called them the Reno regulations for Janet Reno. Remember her? Under the law, Congress said this, except as provided in another subsection. They write, the Attorney General may appoint a U.S. attorney for the district in which the office of the U.S. attorney is vacant. Okay, very simple. That's the law, 546 subsection A. By its plain terms, that power is subject to one and only one exception, subsection B, which bars appointing individuals to whom the Senate refused advice and consent. So if the Senate says, okay, we considered that person and no, then you can't appoint that person. Now, all agree that the office of the U.S. attorney for this district was vacant when Halligan was appointed. That's the law. And no one claims that subsection B applies because the Senate has not even acted on Lindsay Halligan's nomination. So they haven't rejected her. Because this law is plainly satisfied, that's it. That's the end of the discussion. Lindsay Halligan's appointment is valid. Now, Comey and Letitia, they say no. If you look at other sections, though, like if you look at the sub B, C, D, E, F, whatever, it impliedly, it doesn't say it explicitly in the law. It's like, well, it kind of says, it's like implied, it's the implication, saying it prevents the Attorney General from appointing an interim U.S. attorney 120 days after her first interim appointment. So you only get like one shot at it. You can't do it again after the fact. But the law says no, it doesn't say that at all. 546C2, another provision that they're trying to latch onto to say Lindsay's disqualified, it permits a person appointed to serve until the expiration of the 120 days. Thus, each appointment under the law may not exceed 120 days. The Attorney General must revisit her choice periodically, consistent with the nature of interim appointments. Instead, Letitia and Comey, they read the section to impose an aggregate 120-day limit as if an appointment expired 120 days after the initial appointment by the AG. So in other words, it's a shorter time period for the second you'll get 120 days total, and you can't, once you have an interim attorney who's gone, you can't then appoint somebody else. So defendants also invoke another section. It says, after an appointment expires under the law, the district court for the district may appoint a U.S. attorney to serve until the vacancy is filled. Now, by its terms, that other provision offers a parallel track to AG appointments from PAM under subsection A, ensuring that the office of the U.S. attorney is promptly filled. So if PAM doesn't have somebody in the seat, the court can go appoint somebody in the seat. But they say, as if it said that only the district court may do that after 120 days, but it doesn't say that. You get more than 120 days. But again, Congress made a different choice, and now they're seeking to rewrite this statute, which is not right. Even were Ms. Halligan's appointment invalid, even if you said, okay, 120 days, or you can do 120 days, and after the 120 days, do it again, another 120, or do it again, versus you get 120 days total. They say, look, even if she is invalid, you still should reject their motion to dismiss. Now, while they challenge her appointment as the interim U.S. attorney, the actions that they challenge, in other words, they're just fighting Lindsay, they're not fighting the indictment. The actions they challenge do not hinge on her validly holding that particular office. Any government attorney can present a case to a grand jury or sign an indictment, and the Attorney General plainly possessed and exercised the authority to make Halligan a government attorney, as the U.S. attorney is now confirmed. Moreover, any defect in her role doesn't taint the indictments anyways. She was at least a de facto officer, and any errors harmless anyways, since the Attorney General, Pam, indisputably could have appointed her in a different capacity to obtain the indictments. In all events, the government has endorsed the prosecutions. Pam Bondi has personally ratified the indictments to obviate any question as to their validity. And at a minimum, any dismissal should be without prejudice, so we can go get new indictments if you want. Now that Pam Bondi has cured any arguable flaw in Halligan's authority to prosecute. And they walk us through some of the background here. They say investigative and prosecutorial decision-making is in the province of the executive branch. It's under the presidency. The Attorney General is the head law enforcement officer, and they can appoint people. Congress has also provided for the appointments of U.S. attorneys for 4-year terms. But because the U.S. attorneys are inferior officers and subject to the control of Pam Bondi, who is an officer, ultimately the president, Congress may also vest in law the power to appoint U.S. attorneys to the president alone. So lots of rules and backgrounds. We've got the Vacancies Reform Act. Attorney generals can appoint things, walking us through the statutes that we saw. And Congress has authorized a lot of this, lots of laws. You see all the subsections listed out. We can fast forward through it because they'll explain it. Now, here's the factual background. On January 20th, Trump took office. What a glorious day indeed. Just pause to remember. And the incumbent U.S. attorney for the Eastern District of Virginia resigned. I'm out of here. The next day, acting AG appointed Eric Siebert as the interim U.S. attorney under the law. Now, Siebert's initial appointment expired 120 days later on May 21st, 2025, and the judges of the Eastern District reappointed him under the law. So we had somebody else before Halligan. Then on September 19th, 2025, this year, Mr. Siebert left, gone. The next day, the president announced his intention to nominate Lindsay Halligan and send her through the Senate. To lead the office in the interim, on September 22nd, Pam Bondi said Halligan is going to be the interim. Okay, so we're going to nominate her for a full position, but until then, she's going to be the interim. Senate got her nomination on September 30th, and we're waiting for some action on that, but they can't even open the government. But after Ms. Halligan's appointment as the interim U.S. attorney, then on September 25th, just days later, a grand jury in the Eastern District returned a 2-count indictment charging Comey with making false statements to Congress in violation of the law, obstructing, and lying to Congress. Then on October 9th, the grand jury came back and hit Letitia with bank fraud and making false statements to a financial institution and more. Now, for each indictment, the only government attorney who signed these indictments and the grand jury proceedings was presenting basically was Lindsay Halligan. And she's valid. They say this is totally in compliance with the law. U.S. Code says, except as provided in subsection B, you can have an interim attorney. It prohibits someone who has been refused by the Senate, but Lindsay has not been refused by the Senate. Hasn't even happened yet. So the criteria are met here. The office of the U.S. attorney and the Eastern District became vacant on September 19th. We saw him leave. The Senate has not refused to advise and consent. Her nominations are still working their way through. So the AG, therefore, lawfully appointed Halligan as the interim attorney, and all of this stuff should be denied. The cases are that simple. But Comey and Letitia, they say that if we read other provisions, 546C and D together, it really limits the total tenure of the AG's interim appointment to 120 days. So in other words, she's out of time. She loses the opportunity to appoint anybody else in the interim because Eric Siebert was already there for a long time. So he's gone. So she gets 120 days. Your clock expires. Now you can only be appointed by the courts, is their argument. After which only court-appointed interim U.S. attorneys are allowed, saying that this is the rule. Now, they rely on these subsections, which states that a person appointed as U.S. attorney under this section may serve until the qualification or the expiration of the 120 days. They say, what are you talking? She complies with this fully. Senate has not confirmed her, and she has not been in there for 120 days. Nothing in the text explicitly or implicitly precludes Pam for making additional appointments after the 120 days. So she can go back. Oh, your term's expired. Guess what? You're reappointed, Lindsay. And again, and again, and again. Again, subsection A identifies only one exception to that authority. It's subsection B. It's not subsection C. So you can't reference that other statute and say, well, this limits that. No, because it says the only thing that limits it is B. So refer to that. Refer to that. It says it's if the Senate rejects her. Senate has not rejected her. End of the story. Now, if anything, what this says is that the law expressly allows Pam Bondi, says she may make multiple interim appointments by referring to a person appointed rather than the person appointed. See what these lawyers are doing? It's like, oh gosh, a versus the. Let's spend about 50 pages talking about the difference. Defendants recognize as much, but they say that Pam must cram multiple appointments into a single 120-day period. Otherwise, clock expires. But the far more natural reading is that each appointment triggers its own 120-day clock. Each person appointed may serve until 120 days after the appointment. It doesn't mean it's 120 days total. They don't automatically renew either. The process provides political accountability, so Pam has to go and do it again. Ensuring that the appointee without Senate confirmation cannot serve indefinitely without frequent personal review by the AG, who is duly appointed and Senate confirmed. At the same time, Congress did not hamstring the Attorney General with an artificial one-time only appointment window, like use it or lose it. Now the court gets to appoint everybody indefinitely. Now that reading also tracks the ordinary presumption that you would expect. When a statute provides for an appointee to serve a term of 4 years, the specified time of service begins with the appointment. For example, if a Senate-confirmed U.S. attorney resigns before the end of the 4-year term, a new Senate-confirmed attorney is entitled to his own 4-year term. It triggers a new term. Same thing is happening here exactly. You have a new interim appointment, you get a new 120-day clock under the rules, and you avoid any artificial limitations. And by the way, the Fourth Circuit precedent also supports this conclusion. Okay, the Court of Appeals said this in 2024, judges. The circuit addressed a regulation authorizing the appointment of a temporary Board of Immigration Appeals members not to exceed a term of 6 months. An alien sued, said you can't keep reappointing the same person to 4 successive 6-month terms. You get to play 4 times and you just keep getting reappointed and reappointed. The court rejected the challenge from the illegal, recognizing that the regulation's language doesn't restrict the power to appoint the same person to multiple consecutive terms, so successive terms are permissible. As the Eighth Circuit, another court says, in rejecting a similar argument, implying a limitation on successive appointments would be inconsistent if you limit Pam Bondi the broad power to make appointments and delegate duties to their subordinates. And nothing in the law limits Pam and her ability from doing any of this. Now, contrary, the defendants argue, they say no, it has to be 120 days only. They say this is ridiculous. That reading violates the basic rule that courts may not add words into statutes and just shove words in there. This clock that's in the law is from appointment. It says appointment. It doesn't say initial appointment. You shove that in there, but it's not in the law. Their justification for this are also untenable. They make a bunch of arguments, and again, we're talking about the language. They write, Congress, they say from Comey and Letitia, that if Congress wanted each appointment to last up to 120 days, they would have made appointments expire after that appointment or after his or her appointment, rather than 120 days after appointment, right? So appointment, they're saying, that means the very first in time appointment that has ever happened. And if they wanted it to be more specific, they would say his appointment or her appointment or that appointment. So we'll fight over that for a couple paragraphs. Second, Comey says that the government's reading renders superfluous under this statute. But under this statute serves other functions. So if you read it our way, it doesn't invalidate this section of the law. That section still has power. Comey says if you follow what Halligan says, then all of this language is meaningless. They say, no, it's not. It's right here. It's perfectly meaningless. Here's what this does. Here's what this does. It's there for a reason. The logic of the statute is perfectly applicable under our interpretation. Third, Comey asserts that the time limit in the law under C1, that an interim U.S. attorney may not serve once the Senate confirms the nominee, is not appointment specific, but they say it is perfectly clear. It says appointment to refer to the person who is appointed. Seems pretty obvious. But regardless, this does not address a specific appointee because it sets out a condition that does not turn on the status of any interim appointment. Once the Senate confirms a U.S. attorney, the interim office holder is out, regardless of how long he or she served or who appointed her, because you're interim. Then you're replaced by your duly appointed individual, even if it is you. Subsequently, by contrast, this is when the appointment happens. And so their reading also contradicts the statutory history. If you listen to Comey and Letitia's perverted interpretation of the law, it contradicts all of the statutory history that came before the law. Now, as defendants recognize, between 1986 and 2006, this section was identical to the current version. for that long period of time. During that period, the government repeatedly used successive 120-day appointments for interim U.S. attorneys. We've done this a lot. 120 comes and goes, and you can just stay on. So Lindsay, 120, 120, 120. Now, if the Senate hears her and rejects her, then she can't get another 120. So you got to think about that too. For the U.S. attorney, in 1987, the AG reappointed an interim U.S. attorney, same person after the 120-day clock had run. That appointment was challenged in court, and it was upheld. That person was allowed to serve a second time. The CRS, the Congressional Research Service, they also report that between January 1993 and March 2006, at least eight U.S. attorney vacancies, 3 under Clinton, 5 under Bush, were filled with successive appointments. 120, 120, 120. Now, in debating later amendments, Senator Kyle, probably John Kyle from Arizona, identified 2 pre-2006 instances when interim U.S. attorneys served 3 or even 4 successive 120-day terms. As far as the government is aware, the only district court to consider the practice contemporaneously approved it. In this other case, and until the current administration, until Trump came in, guess what? No court even questioned it. But now everything changes because the government is now arming itself against the American people, the courts especially. In 2006 then, so prior precedent showed that other presidents had used this repeatedly for a long time. Bush, Clinton, all of them. Then in 2006, Congress amended the law. They eliminated the district court's appointment power, and they permitted the AG's appointee to serve indefinitely. But following controversy over the Bush administration and their firing back in 2007, Congress then reverted back. So they were going to make it more permissive. They were going to, in other words, let Lindsay Halligan serve as long as she wants. Then Bush screwed it up, and they reverted. Language that was still well understood to authorize successive appointments, turned it back. They write, where Congress has chosen to maintain the relevant provisions and here affirmatively reenacted them, they had it one way, changed it, and changed it back. They say this was ratifying the practice. And citing legislative history, Comey and James, they go back and they say, no. The reason why they made those amendments was to stop these interim appointments. But legislative history is not law, and you can go find reasons why some senators spoke out about it. We have to bring this back and do this. Okay, that's fine, but that's not what the law says. And the legislative history is like looking over a crowd and picking out your friends. Oh yeah, that senator said this or that. So the purpose of passing the new amendment was to do whatever. Well, did that make it into the law? Like, did they write that into the law that this is what we're doing? They didn't? Oh, great. Then it's just back to the way it was. And you didn't stop it. So it's like you're ratifying it. While some members certainly wanted to prohibit this, Senator Kyle correctly pointed out that because the bill reinstates the exact language that existed before the amendment, the AG could make successive appointments. They just kept it the same. If they wanted to prevent successive appointments, why didn't they put that back in there in the amendment? Congress was even aware of this and said that the Attorney General could rely on pre-existing legal rationales to specifically make successive interim appointments. And the Senate rejected, in fact, an amendment that would have repealed this authority altogether. That was rejected. If Congress wanted to block these appointments, then they could have done it. Returning to the former text and just saying everything is exactly like it used to be is a bizarre way of eliminating that limitation. Instead, the 2007 amendment means what it says. It says the AG can no longer make a single indefinite appointment as she could under 2006. She has to go revisit it every 120 days. And courts may once again appoint interim U.S. attorneys as a backstop. Courts have the power if they can't get the slot filled. But in reenacting this pre-2006 text, Congress presumptively ratified this long-standing practice that Bush and Clinton all used. Successive 120-day appointments under that law is permissible. Now, Comey and Letitia, they also go back to this 1986 memo by the Supreme Court judge, who was not the Supreme Court judge at the time, Samuel Alito. He was a deputy assistant attorney general, and he wrote this memo. identifying a purported congressional purpose that after the expiration of 120 days, interim appointments are to be made by the court, right? So Alito in this memo is saying, well, you do get 120 days total, is what Comey and Letitia, and they're writing for one audience up there, Judge Alito, saying, hey, remember that memo you wrote, Judge, back in 1986, where you said it's 120 days max, then it goes to the courts? That's why we're here. But the DOJ says, consistent with the era in which it was written, the extent of the memo and their analysis is a citation of a single House floor statement, and it's not the law. Now, here they write, Alito wrote this, declining to follow the approach of a 1986 case that jumped right to the legislative history rather than starting with a text of the law. And the cited statement does not even suggest that the AG cannot make multiple appointments that total over 120 days. The congressman that Alito was referencing merely said that once an interim appointment expires, the judge can then appoint a U.S. attorney. Okay. Not that they're not getting reappointed. Like if it's empty and there's no one coming in there, yeah, the courts can fill it. The government cannot let 120-day appointment lapse, but multiple shorter appointments may be allowed. Now, in any event, they say the memo from Alito left open whether the AG could make an additional appointment if the district court failed to act. And so that refutes Comey's claims entirely, saying it's the same approach. It's not. Subsequent DOJ practice also after Alito rebuts any suggestion that the AG is limited to one single 120-day period, and many successive interim appointments can be made in the aftermath. Continuing, Halligan responds to Comey and Letitia. They also say, such a dumb argument from these two. They say that there are other implied limitations. Here, Eric Siebert, the first interim, his initial appointment expired on May 21, and the judges of the Eastern District appointed him to a new term, subject to presidential removal. But he then vacated his office on the 19th, and nothing in the subsection limited Pam's ability to put somebody else in there. It's exactly what she did. And the law refutes Comey and Letitia. Subsection D says that the district court for such district may appoint a U.S. attorney once a 120-day appointment has expired, not that only the district court may appoint. It says that they can, but not only they can. So that means that Pam can do the same. And we have parallel tracks on this all the time. It's either the AG or it's the courts. It's the AG and the courts. If the AG doesn't act, the courts will backfill it so justice can carry on. Parallel tracks are especially common in this context when talking about appointments to ensure the continuity of government. For example, this other provision allows the AG to designate certain subordinates to serve as acting AG during future vacancies. We've also got Fourth Circuit in this case law and more. They also accept that Pam may make at least 120 days worth of appointments in other contexts. And they understand, they even recognize in their own motions the importance of these mechanisms. But they're also not correct that concurrent authorities would create conflict. They're saying, well, what happens if Pam wants to shove someone in there and the courts want to too? This is going to be a conflict that's going to wreck everything. Now, to the extent whether there is a dispute over whether a district court or the president should decide who gets to wield this power, the Constitution is clear. It's the president. The president makes those appointments, and that's going to override the judges trying to usurp him. In any event, there is no conflict. In this case, the district court did not appoint anyone in the days after Siebert left, and Lindsay Halligan came in and took the spot. So there is no conflict at all. Now, at bottom, Comey and Letitia's arguments, they sound in policy, okay? Not the text of the law. They're not looking at the statute. They're just saying, well, we kind of would prefer the policy, and we think the policy is better this way. Okay, well, you're not Congress. Congress sets the policy, and they've got the wherewithal, arguably, supposed to make those determinations, weigh out the policy considerations, and come to a final conclusion and write it down in the law. If the AG could string together 120-day appointments, they say, the executive branch could circumvent the district court's role in all of this. But even the most formal policy arguments and formidable policy arguments, they say, cannot overcome the law, a clear statutory directive. Just because you don't like it doesn't mean you can override the law. Lots of judges are doing that these days, however. And Comey and Letitia's concerns, they ring hollow, given that the government previously let the district court make an appointment and has now submitted Halligan. We're going through the literal process. There's no conflict at all. And we secured Senate confirmation of 16 U.S. attorneys mere weeks ago in those blanket hearings. Now, defendants and their policy, so Letitia and Comey, they also assume that the conclusion of the law seeks to make the court, not the AG, the sole appointer of U.S. attorneys, which is obviously ridiculous. It's not that. It's a failsafe. Their own reading of and interpretation also doesn't guarantee that the courts make the appointments. And even the Alito memo says that successive appointments might be appropriate if the district court fails to act. So both sides are covering for each other. They're both working on filling the spot. Now, Comey and Letitia, their concerns over bypassing Senate confirmation are also particularly puzzling here. They're saying, well, if you can just keep appointing 120 and 120 and 120, you don't even have to send them over to Senate confirmation. And then you can have somebody who's kind of, not a confirmed attorney prosecuting all these cases. You see, but this is puzzling. Even on their reading, court-appointed interim attorneys can serve indefinitely. So if you follow their rules, that still is bypassing the Senate. If the court appoints somebody, how's that different than the executive appointing somebody? Historically, district courts have overwhelmingly reappointed the attorney general's choice until the Trump era, as has happened with Mr. Siebert and multiple U.S. attorneys in the Fourth Circuit this year. Now, in practice, Comey and Letitia would frequently allow the president's pick to serve an entire 4-year term or longer without even a periodic assessment. So there is a reason, however, that lengthy interim appointments are the exception, not the rule. In addition to obviating the need to revisit an appointment every 120 days, the imprimatur of Senate confirmation offers tangible benefits, telling courts and litigants that the two branches of government are backing this attorney. The executive have little incentive to forego those benefits across the board, which is why the presidential appointment and Senate confirmation remain the norm, even though this allows us to fill the vacancies. Like, we want somebody who's got the stamp of the Senate in addition to the House, to the executive. And again, the claim that the government engaged in a gambit makes little sense. We're following the rules exactly. We made appointments. Halligan is making her way over to the Senate. So there's not this attempt to run around the Senate. Now, to the extent that the law is ambiguous, if you go, well, we don't really know what it says, constitutional avoidance, which is this principle that you don't go looking, the courts shouldn't be looking for conflicts because we're all part of the same government, but currently they have. It favors our reading. There are few functions more quintessentially executive than prosecuting crimes. It's what they do. Article 2, therefore, requires that the president have complete control over the investigation and the prosecution of the law. And Article 3, which is, so Article 1, legislature, Article 2, executive, Article 3, courts. Article 3 requires courts to carefully abstain from intruding on the executive branch. Now, Congress may permit courts of law to appoint some inferior officers, but Congress may not do so in a way that is incongruous with appointers' judicial duties or which interferes with the executive. We've got separation of powers that need to be respected. Now, their position from Comey and Letitia would take us into a constitutional disaster. It would allow Article 3 courts to control the appointment of an executive official even over the president's objection, if they got their way. On their view, once the 120-day clock has run out, only the courts can appoint a new attorney until somebody is Senate confirmed. The president, of course, remains free to remove whomever the court selects, but that arrangement raises the possibility that the courts repeatedly could continue making appointments unacceptable to the president, and the president could continue removing those people until the court picks someone that he likes. Now, that regime is profoundly destabilizing than the one where the attorney general and the district court make simultaneous picks and the attorney general's pick prevails. Lots more, we're working together. Courts should strive to avoid, not embrace, these interbranch conflicts. This raises serious separation of powers issues. Now, this case illustrates the dangers right here. Presumably because the previous interim U.S. attorney was appointed by the Eastern District, those judges on their own, sua sponte, transferred the present motions to this court. Other courts have felt compelled to transfer similar cases, and courts should avoid an interpretation that would routinely put themselves in an uncomfortable position. You're not supposed to be in the middle of the conflict. Instead, consistent with the Constitution and the Appointments Clause and the separation of powers, Congress gave the courts only a narrow but important role of making the seat filled when political branches ultimately fail to act. And they haven't done that now. Lindsay Halligan is in the seat. But as a backstop, even if you find that Lindsay Halligan and her appointment is invalid, you should not dismiss these cases. That doesn't make any sense at all. Even if it was invalid, which we're saying it's not, dismissal with prejudice so we can't recharge these people would not be an appropriate remedy for what is the most procedural, at most, a procedural misstep in how the phrasing of the appointment occurred. James's request for relief should also be denied because Halligan has been reappointed, just to be clear. Now, her motion, Letitia's and Comey's motions, they evince a fundamental mismatch between their asserted violation and their request for a dismissal. What was the harm that came upon them? What is the remedy that they deserve? While they assail Lindsay Halligan's purportedly unlawful title, their indictments in no way depend on that title. No federal rule exists which demands that a U.S. attorney, somebody Senate confirmed and lawfully appointed, sign every indictment. You can just be an attorney working for the government. Instead, an indictment only needs to be signed by an attorney for the government. That's it. Federal Rules of Criminal Procedure 7C1. Likewise, attorneys for the government may conduct grand jury proceedings. So even if Lindsay, if you say she's not interim, she's not acting, she's like the lowest attorney government worker, great, still can do it according to the rules. Likewise, attorneys for the government may conduct grand jury proceedings. In many districts, assistant U.S. attorneys routinely sign indictments, and any vacancy or defect does not affect their power. That's because their ability to do this does not hinge on the authority of a local U.S. attorney, but it's coming from the AG, which has plenary power, broad power over litigation where the U.S. government is a party. So likewise, any flaw in this appointment as the interim attorney does not affect her ability to exercise Pam Bondi's power. Whatever her title, Halligan is still an attorney for the government, authorized to conduct grand jury proceedings and sign indictments, just as she is an attorney for the government bound by the grand jury secrecy rules. She's protected by the government's attorney-client privilege rules. She's entitled to a federal paycheck after the shutdown's over. The federal rules define an attorney for the government is not specifically a U.S. attorney or assistant U.S. attorney, but it's any authorized assistant to Pam or any other authorized by law to conduct proceedings as a prosecutor. Now, the Attorney General, Pam, has broad powers. She may appoint people. She's done that. Individually and collectively, these authorities amply authorize Halligan to conduct the prosecutions authorized by Pam Bondi. And if you have any questions about it, let's be sure. Miss Halligan's original appointment cited only Section 546, consistent with the government's view that she's not limited to 120 days. But an agency doesn't need to cite specific statutory provisions on which it relies when making a decision. Look at this case from the Supreme Court. And courts ordinarily interpret legal text to avoid rendering them invalid. And Scalia wrote that. May he rest in peace. There is no question that Pam Bondi intended to vest Halligan with the powers of a U.S. attorney and thus authorize the litigation. She recently confirmed this as well. Now, Halligan's original appointment should not be read to nullify because it came from Pam. Even if Halligan lacked the authority, the indictments are still valid for three other reasons. Let's say you take Lindsay out. First, the Fourth Circuit Court of Appeals has long said that the signature of the prosecuting attorney is no part of the indictment and is necessary only as evidence of the authenticity of the document. That means if you have somebody improperly signing an indictment, it doesn't invalidate the indictment, Fourth Circuit. It's a mere technical deficiency. It's not automatically fatal to the indictment anyways. Citing a bunch of cases. Multiple courts, therefore, have held that an indictment is not valid if the prosecutor was not licensed to practice law, if other evidence was not invalid, let me say this, if they're not licensed to practice law, if other evidence indicates the government endorsed the prosecution. Man, that's crazy. So don't even have to be a lawyer. From Massachusetts, 2019. For example, where the only government attorney to present evidence to the grand jury and sign the indictment, in this case, this person was suspended from practicing law. A court still said, well, the indictment is valid because other government lawyers agreed with the grand jury that the indictment should issue and they signed it on later filings. Gosh, that's crazy. So a prosecutor who's suspended can still indict you in Massachusetts. Incredible. Those cases confirm the validity of these indictments, and Lindsay is not suspended. There is no question as to the indictment's authenticity or the grand jury return of it. Other federal prosecutors with unchallenged appointments have signed subsequent filings, and the AG has personally ratified everything. So that readily distinguishes this case from other cases where there was no official approval of anything. So it's valid even without her. It's been ratified by the rest of people who are. Second, even were a government's attorney signature necessary, and even were Halligan not a government attorney, her actions would still have de facto validity. They say the de facto officer doctrine confers validity if they're acting under the color of law, when it's later discovered that they are deficient. This doctrine springs from the fear of chaos that would result if every action was challenged. Even if the attorney general failed to properly appoint her as an officer de jure, she was acting under the color of law, and so her past actions are valid and binding. But Comey and Letitia say no. They try to bootstrap their claimed violation. They say if this is a violation of the appointments clause, just like Jack Smith, citing the Supreme Court case, declining to apply this to certain appointments clause claims. They say this case distinguishes their arguments, but on their theory, every statutory violation would become a constitutional violation since the appointment in violation of a statute would not be authorized by law. And so this concept doesn't apply, and other cases are even further out there from them. They invoke another passage in Collins versus Yellen, a 2021 case. But the cited passage that they reference merely described how the challengers characterize certain cases in distinguishing those cases and rejecting their argument. So it's actually helping us, not them. Why are they citing that when it supports our claim? There, the court found that the appointment was unconstitutional and irremedial because there was no statutorily created office to fill in the first place. Like the entire office was invalid. This office is not invalid. Your case doesn't even matter to what we're arguing here. Even on its own terms, that reasoning has no application here. The office of the U.S. Attorney plainly exists. The question is only whether Halligan is properly filling it, not whether it's real or not. So why are you citing that case? Third, any error in their indictments are also harmless. The grand jury, had proper independence and decided to act, and they're a check on the whole process. Failures by the executive branch, even prosecutorial misconduct, provide a court no authority to dismiss this. You have to have a finding that the defendant was prejudiced by the misconduct, and that rule applies here too. You can't dismiss it unless you can show some real problems. In this context, prejudice that they would have to show would mean the government and their misdeeds substantially influenced the grand jury's decision. And there's grave doubt that they were free to make a fair decision at the grand jury stage without that improper influence. They can't show that at all. Given Pam Bondi's expansive power to appoint these people, there's no question that she's made explicit that AG Bondi could have authorized Halligan to do all these things. Even if she's not even an interim attorney, she could have done those. The AG could have also hired Halligan as an assistant attorney, making her an indisputable attorney for the government. Now, their basic claim, therefore, is at most, if you look at it and find in their favor, it's at most a paperwork error, that the AG should have cited a different provision in appointing her. And that would have then satisfied everything. But absent her view that she would have been excluded, she would have simply had a different title. That's it. The kind of technical difference cannot establish any grave doubt that's required under the statute. And so they don't want you to even think about harmless error altogether. They say you can find this other exception when it's a structural problem that renders the grand jury proceedings fundamentally unfair. But that exception is exceedingly narrow, and it's exemplified by major structural errors, like where black people had been systematically excluded from the grand jury, or the intentional exclusion of all women from a grand jury. That precedent reflects the special problem of racial discrimination, a problem so pernicious that you don't have to show prejudice. But all of this is far outside anything that's applicable here. Any defect in her job title is not even remotely comparable to the wholesale exclusion of minorities from grand jury proceedings. Now, in any event, Halligan's team says, the Attorney General, in whom Congress has empowered to run the DOJ, she has personally ratified all of these indictments. When an officer allegedly appointed in violation of the Appointments Clause takes a challenged action, subsequent ratification by an official with the power to do so cures any defects that may have existed. Fourth Circuit said that in 2025 in October, not long ago. Here, Pam Bondi plainly could have authorized any DOJ officer to go do this and indict these people on her personal authority. And so this ratification from Pam now cures any flaws in the indictments. Now, Comey may respond that a ratifying principal must have been able to take that action at the time the ratification was made. But when a timely filed indictment is dismissed for any reason, we might be able to refile it if it's dismissed without prejudice. Because the Attorney General could go get a new indictment, she may ratify this. So it goes back to her power, not Halligan's. Comey raises some other disputes about refiling indictments, but he does not dispute that a validly appointed federal prosecutor, could be a U.S. attorney, could be assistant U.S. attorney, could be a special attorney, could be Pam Bondi herself. They could have lawfully obtained this indictment. And so the tolling rule would govern any dismissal. Now, at minimum, if you are going to dismiss this case, you need to do it without prejudice, which means the government can come back and refile it. Just go get a new grand jury. Now, the problem with the Comey case in particular is a statute of limitations problem, but they would make the argument that this relates back to this case. We would see how that, if I were defending Comey, would obviously object on that. New indictment, statute of limitations has expired, can't do it, but we'll see what the courts say. But James does not request dismissal with prejudice and thus forfeits any request. The maximum relief to which James could be entitled is without prejudice, a remedy that would allow Halligan or any other attorney to now indict them again. Comey does want a harsh remedy. He wants a dismissal with prejudice, but he says that sanction is reserved for flagrant misbehavior, substantial prejudice, where no lesser sanction will do. But he can't prove that here. He's going back. He's rehashing his vindictive and selective prosecution claims that are of a different motion in front of a different judge over which this court lacks jurisdiction. But if the judge, Nachmanoff in the original case, and remember the judge sent off the disqualification case to another judge, if Judge Nachmanoff accepts those allegations and grants the motion, this court would have no need to adjudicate this motion. So you should, in other words, if the case is dismissed for selective and vindictive prosecution, the case is dismissed. It doesn't need to be adjudicated to be dismissed on the basis of an unlawful appointment, which is a different issue. So the court should therefore proceed on the assumption that his selective and vindictive claims also fail, and or defer this until that is ruled on. So you can't, commingle the claims. This is separated out for you to make a decision on disqualification. Now, zeroing in on an actual claim here, that the Pam Bondi Attorney General could not lawfully invoke this to appoint Halligan, Comey comes nowhere close to showing flagrant misbehavior, substantial prejudice, the availability of a lesser sanction at all. He suffered no prejudice, much less any prejudice based on Lindsay Halligan's title when she was standing in the grand jury room. And contrary to his assertion, the counterfactual where Pam Bondi did not, in his words, unlawfully appoint Halligan is not a world where the government would have let the limitations period run. Instead, Bondi would have cited a different authority that would have authorized Halligan to get the same exact indictment at the same exact time. If the court deems the indictment invalid, any dismissal should be without prejudice to permit the government to swiftly seek re-indictment under 18 U.S. Code. So you can get very conspiratorial here. I paused there for a moment. I was like thinking about that. Yeah, what if your indictments are tainted from the very beginning because your attorney is unlawfully appointed? Okay, so all of this is just now going to make sure that they cannot get indicted because the judge could dismiss them with prejudice. And then everybody just goes, oh, Pam Bondi just blew the whole thing. Oops, accidentally appointed Lindsay in a wrong way. And the courts come out and dismiss everything with prejudice, and you can't refile it. It's a cover-up. It's a legal cover-up, right? If something like that were to happen intentionally. Or maybe Pam just, screwed up the appointments or something. But if that happens, it's going to be real problems. James, not Comey, also requests an injunction to stop Halligan from prosecuting anyone else. To the extent that she requests an injunction, it's also improper. Equitable remedies like injunctions must be party-specific. She has no standing to seek an injunction against Lindsay Halligan. James's request is also improper to the extent she seeks an injunction. She may seek to disqualify Halligan, but her request has been overtaken by events. She can't be injuncted on anything. Pam Bondi has ratified Halligan's appointment as a special attorney, and because Halligan now has indisputable authority to proceed, any prospective relief in that regard would also be inappropriate. So that is the response from Henry C. Whitaker to the attempts by James Comey and Letitia James to disqualify Lindsay Halligan, and a lot of similarity to the Jack Smith disqualification attempts where we said he's not a real boy, although the appointment powers and the statutes that we're talking about are very different. This is talking about being appointed as an interim attorney, where Jack Smith was allegedly appointed illegitimately, according to canon, as a special counsel. And they cobbled together a bunch of other authorities to create him, called the Reno Regulations, which we've gone through here many times to show what a joke they are. They're like FBI statutes and other DOJ statutes and like a Bureau of Prison statutes. And they cobble all those together to say, you're a special counsel now. You're not an acting attorney, a government attorney, or you're a special counsel. And under those powers, you can go do these things. And that was all illegitimate, obviously. So it's similar in form, but very different in statute. And so nice response over here. It makes me nervous on this because the judges, as we know, I think this one is going over to a different judge, but Nachmanoff and others are blue judges who may dismiss these cases, just based on some justification that they pull out of their booties. But ultimately, a motion to dismiss is a big, big decision. And we'll see what the courts do on this, but we're happy to see a very strong response from Halligan and the team, just showing very clearly, statute says we can do this. Prior precedent confirms that. It was this way for a very long time. Congress tried to make it more expansive and reverted back to the exact way it was that allows these appointments to continue. But these judges, man, any little gap you give them, we've seen them exploit to create nationwide injunctions that prevent illegal aliens from being deported and all sorts of other insane things. You have to pay the thieves billions of dollars because of democracy or whatever, right? They just make it up. So we'll keep our eye on this one, but Lindsay Halligan and the team now responding to Comey and Letitia, and we want Halligan to stick around because thus far, she's been the only one with any testicular fortitude to actually charge anybody anywhere, and we'll continue to encourage her office to continue. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right, now we got a little lighter stuff coming up next, including some Jack Smith scandalous behavior. President Trump's phone records now confirmed to have been seized by Jack Smith. We've heard rumors about this before and had releases from Congress, from Chuck Grassley and others. But now Pam Bondi, who is in the executive branch running the DOJ, she's confirming it from her chair. She's saying, oh yeah, not good. And Jack Smith has already been under scrutiny and with demands from the Senate and the House to prosecute him, to impeach him. Tuberville says, throw him in jail. Pam Bondi is the person who could make that decision. And here's what she is posting about what she's discovered from her position. It says, during the Arctic Frost investigation, which turned into the Jack Smith prosecutions, we found that Jack Smith seized President Trump's government-issued phone. This means the Biden administration turned over President Trump's phone to the special counsel, which is an unprecedented action, okay? We've known that. They got his phones. They got everybody's phones. They were going after senators and more. But in addition, Jack Smith also subpoenaed, just like he did the senators, all of President Trump's personal phone records as well. We can never again, says Pam Bondi, allow this kind of government weaponization in America. I submitted these new documents to our partners on Capitol Hill. For what? I commend our team at the FBI for working diligently to expose this. Okay, well, the Senate, Congress already knew about this. And they're not the prosecutors over there, Pam. So thank you for alerting them to this, but pretty sure they already knew. The question is, what are you going to do about it? You're the prosecutor. We can never allow this weaponization in America to happen. So indict somebody. All right. So they have, of course, indicted some people. We've got Comey, who is a part of all this scandalous behavior, who got indicted. But Jack Smith has not been indicted, nor have any of his prosecutorial goons who used to work for the DOJ, like Jay Bratt and the rest of them. So Pam Bondi came out and she says that we appreciate the reveal on it, but hopefully she's going to do something about it because Congress can't. So the fact that she's letting them know about something that I think they already knew, thanks to the whistleblowers, isn't that great? But it is interesting to hear from the AG of America. Now, it's not just Trump. Grassley over on Capitol Hill and Ron Johnson, they say, I received recent information from Verizon also showing that Jack Smith subpoenaed more than 2 years of Kash Patel's phone records. So add Kash to the list. 8 senators, House of Representatives, Trump's private and personal cell phone, and now Kash Patel also scrutinized. From 2022 to 2023, that's not exactly around J6. This is yet another example of the partisan misconduct of the Biden DOJ and the FBI that led to the outrageous targeting of law-abiding, innocent Americans, including Kash. And you can see why they were so upset that he was going to come in and have access to these materials because they were spying on him. Wonder what they got. And I wonder if Kash is going to demand some action on that. So Caroline Leavitt came out and she's explaining more. She says, yep, this is what we're seeing here, and this is an egregious overreach that we are going to be addressing. Here's what Caroline had to say about this during the press briefing yesterday.
But first, I'd like to ask you about breaking news from the Attorney General. She revealed just about an hour ago that the Biden Justice Department seized President Trump's official first-term phone and subpoenaed his private phone records. Do you have a reaction to that? And also, do we know if they actually got those private call records?
I saw the Attorney General's post on that. For additional questions, I would refer you to the Department of Justice, but I think this is just further evidence of the egregious overreach and weaponization of government that took place under the previous White House against then former President and now President Donald J. Trump. It was a clear effort by the Biden White House and the Biden DOJ to go after the president, and this is just further evidence of that.
It is further evidence of that, and we've got more from other senators, including Rick Scott. He says, after Verizon, who handed all the documents to Jack Smith, after they rolled over and complied with the Biden administration's Arctic Frost witch hunt against my colleagues and me, I, the senator, am demanding an explanation from Verizon about their role in exposing my data during this unlawful investigation. Rick Scott sends this one over to the CEO, Mr. Daniel Schulman of Verizon. He says, all right, Daniel, this is a senator speaking. As you are already aware, The Biden administration spied on Republican members of Congress and subpoenaed their cell phone records during Arctic frost. The Biden administration's secretive surveillance of Congress not only represented a desecration of our constitutional separation of powers, but it also appears to have violated federal law. Mr. CEO. U.S. Code states in clear and unambiguous terms that any provider for a Senate office shall not be barred through operation of any court order or any statutory provision from notifying the Senate office of any legal process seeking disclosure of Senate data of the Senate office. So Verizon, you cannot not disclose to us when our records are being demanded. When Biden appointed special counsel Jack Smith subpoenaed Republican senators' phone records, Obama appointed Judge James Boasberg. He ordered the phone carriers, quote, not to notify any other person, including the targeted senators and their office staff, of the existence of the subpoena. In doing so, James Boasberg, he made findings. He said that these senators might destroy evidence or what? Or intimidate witnesses. What was presented to him to show that Ted Cruz would do that? Of course, the mere suggestion of impropriety, says Senator Scott, he says, is insulting and offensive. But more importantly, this gag order appears to have violated the law. So I'm very disappointed in you, but you're also a criminal. Furthermore, this section of the law also says, if either a Senate office or provider files a motion to quash a subpoena that requires the disclosure of Senate data, the court shall quash the subpoena or modify it so as not to disclose the data. So the Senate has a lot of power. If the court comes breathing down their neck, they can say, no, if we quash it, you shall quash it, and then we'll fight about it. Understanding that the gag order and the subpoena were unlawful, Mr. Verizon, your competitor, AT&T, who I need to switch to, understands AT&T appears to have rightfully refused to comply. Verizon, however, appears to have complied and handed everything over right to Jack Smith. And I want to know who is a part of that review team. You guys, Mr. Verizon, appear to have rolled over and complied with the unlawful subpoena and the cover-up of the whole thing. Verizon claims, they said, well, a court ordered Verizon not to tell anyone. A judge told us it had no choice but to comply. In violation of the law. AT&T's lawyer said, okay, sorry, judge, we're not going to be handing it. You're going to anger the judge or the Senate? AT&T said, how about we just don't do anything that's illegal? But Verizon didn't. They just said, oh, here you go. Because you probably had a bunch of blue people who are like, oh, gosh, Marsha Blackburn, I hate her. Here, have all of her records. But AT&T, if AT&T refused to comply and Section 6628 clearly states otherwise, then presumably Verizon did have a choice. You say you didn't, but your competitors who are much smarter than you did. It just failed to make the right one. You had the choice and you done goofed. I am a Verizon customer, says Senator Scott. And I recently discovered that my Verizon data was targeted by the subpoena and the unlawful gag order from Jack and James. Rather than notifying my office that my Senate data was being compromised, as the law says you have to do, Verizon concealed this information from me. And Verizon also failed to file a motion to quash as provided for in the law. I am deeply disappointed in Verizon's failure to notify me or my office that my Senate data was exposed, as well as its failure to make any effort to protect my data. And so, while I understand this decision was made before your appointment as CEO, I request a full explanation from you, no later than November. 1, why did Verizon fail to file a motion to quash and so readily relinquish my data? What measures has Verizon taken to ensure this does not happen again, including changes to service agreements and training protocols? And what disciplinary measures were taken against those within the company who so readily rolled over and complied with the Jack Smith farce? That's the question that we want answered. We'd like to have them also hauled in front of Congress to explain themselves. I ask these questions not only for myself, but also on behalf of the millions of Americans who believe their data is safe with Verizon. And I got to get off that platform. Sincerely, Rick Scott, United States Senator, over to Verizon. It's a nice letter, and I hope they answer those questions. And if not, why don't they haul Mr. Daniel H. Schulman into Congress to explain himself? That would be nice to see. And hopefully many Americans are also reconsidering what phone company they'll be using in the future. Rick Scott came out. He said, I've been targeted repeatedly. Clinton and their DOJ targeted me after I went after Hillary Care. Biden's IRS released my tax returns. Biden's DOJ targeted me because I'm a Republican. This is the third time the Democrats have weaponized the justice system against me. And this time it was weaponized against my colleagues too. It's an abuse of power, and we need accountability now.
They pursued in my records, and they asked Verizon to give me information on text, voicemail, how I paid my bills, all sorts of things like that. And this is the third time. So they tried to shut me up as a business guy. Then they tried to embarrass me with my tax returns, and then this.
Happens constantly, because that's how the Democrats play the game. So we have Jim Jordan, who's also opening up a probe now. You know how we love us some Jim Jordan letters over here. We got one, not a long one, unfortunately. Jim was busy, but Jim Jordan, chairman of the Judiciary Committee from Ohio, he also sends a letter over to Dan Schulman. He says, all right, Dan, guess what? Senator Scott's not happy with you. Neither am I in the House. The Committee on the Judiciary is conducting oversight of the Biden-Harris DOJ and their politically motivated prosecutions of President Trump and its investigations into the J6 Capitol riots. Recently released internal documents indicate that Jack Smith compelled the production of phone records belonging to several Republican members of Congress and simultaneously sought a gag order to prevent your company Verizon from disclosing the DOJ subpoenas to these Congress people. These findings raise serious concerns about potential statutory and constitutional violations, including violations of the speech and debate clause. And we therefore, Daniel, request information that we need for our oversight. On May 25th, 2023, Jack Smith issued grand jury subpoenas to Verizon and AT&T, requesting phone records of several subscribers for the dates January 4 to January 7th. Although Kash Patel was way broader, 2022 to 2023. Writing, the subscribers included 8 Republican senators, 1 Republican representative. Accompanying the subpoena from Jeb Boasberg was a gag order approved by the chief judge for D.C., Jeb James Boasberg, prohibiting you, Verizon, from notifying any of us about the Biden-Harris request for our records. It is concerning that the Biden-Harris DOJ abused its federal law enforcement authority to effectuate a politically motivated prosecution against Trump in such a clandestine and partisan manner. Dan, what happened? By spying on the communications of sitting members of Congress. And so to assist with our ongoing oversight, the Judiciary Committee wants the following from you there, Mr. Schulman. All documents and communications referring or relating to Jack Smith and the grand jury subpoenas sent over to your company. We want all documents and communications referring or relating to requests by or subpoenas from the DOJ to Verizon for any of these events, including the court filings. And we'd also like to see all documents and communications between or among Verizon employees, agents, or contractors, and people on Jack Smith's team. And so Verizon, you guys better get on this. Please provide this material no later than November 18th. We have a lot of power to do this, and we're going to. Sincerely, your friend, Jim Jordan. Enjoy the letter. Hopefully, they respond and name names, because we want to know who approved it. We know that there were employees in there that were like, oh yeah, here, oh, they're Republicans. Well, a judge told us to do it, so we have to just do it without even following the law. Marsha Blackburn, not happy about this. Here is what she said as they start to call for Boasberg's impeachment.
Each subpoena on all 9 of us had a non-disclosure order on top of the subpoena, which the order was, you can't tell us about this. And they were afraid we would be a flight risk or destroy evidence or tamper with evidence or intimidate witnesses.
Wow.
And of course, as we have learned, all of this, everything they've done is a violation of our First and Fourth Amendment rights. It's a violation of the Speech and Debate Clause and of the Stored Communications Act and the separation of powers. So we are pushing Chairman Grassley to call in Judge Boasberg and have a hearing with him. I think it's appropriate for the House and Chairman Jordan to begin impeachment proceedings on Judge Boasberg. There are 197 separate subpoenas affecting 430 organizations and individuals, all conservative.
Yeah.
In a massive Democrat dragnet to wipe out their political opponents. And the Republicans, if they just sit there and bumble around until the Democrats get back into power, there will be no consequences and they'll be in big trouble on the receiving end. Here's Jim Jordan talking more about this on With Maria. He's explaining what the latest is from the Judiciary Committee. Here is Mr. Jordan.
It's interesting that Verizon is saying that all they saw was the names. That may be the case on the subpoena. That actually is the case. They send them, here's the phone number, give us the logs, who they called, when they called them, give us that information. But what I want to know is, what did the judge know? What did the judge know who issued the non-disclosure order saying to Verizon, you can't tell the person who has that phone number, whose phone logs the government is getting, you can't tell them that this is taking place. Did the judge know that it was the president's phone, that it was Senator Cruz's phone? I mean, that's something that we're going to look into as well. I think that's important. You would think that the judge did when he issued the non-disclosure, when he put the gag order on it, but we don't know. So we're going to find out that fact as well. But I think Caroline Leavitt is exactly right. You talk about the weaponization of government, going after your political opponents. That's what this was. Because Jack Smith, Arctic Frost, which then gets merged into Jack Smith's special counsel investigation, they went after the Republicans, plain and simple. I mean, all kinds of members of Congress, the president, the vice president, and of course the Republican Party, and all kinds of entities associated with the Republican Party. This was, as Caroline Leavitt said, the weaponization of government in its worst possible way. And that's why we're going to bring Jack Smith in and depose him after we get all the information. And frankly, the sooner the government gets open, the easier it will be for the Justice Department to get us the information we're asking for.
Well, it's pretty incredible.
All right, so Jim Jordan's like, well, maybe Jeb didn't know that he was spying on senators and House representatives. Come on, Jim. He knew. He was giddy about it. He was gleeful. He's like, oh, what do we have today there, Mr. Jack Smith? Lawfully appointed? Here you go. Stamp, 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 handing them out. So don't drag your feet on the impeachment stuff as you make up probable explanations for corrupt judges. Make him come in there and say, I didn't know. But the impeachment must begin. All right. So we'll see if it does. We have some developments on that. Articles of impeachment filed against Judge Jeb James Boasberg out of the District of Columbia. We've covered this judge a lot. You remember, this is what he looks like. Very old photo from 2016. And he was appointed a long time ago by Barack Obama. Seeing that right there. And it's been a major thorn in the side of the new Trump administration, issuing nationwide injunctions, ordering planes full of illegal alien terrorist gangbangers to be returned to the country. And now we're seeing that he was also responsible for spying on senators, Republicans, and in the House representatives in both bodies. So now we see Representative Brandon Gill has introduced articles of impeachment against the judge. He comes from Texas, just introduced November 4th, referred over to Jim Jordan and the House Committee on the Judiciary, saying it's time for Jeb to be removed. Here's the background. Articles of impeachment filed, joined by many other people: Chip Roy, Randy Fine, Byron Donalds, Lauren Boebert, Anna Paulina Luna, Andy Biggs in the house, Mr. Self, Stuntsman, Crane, Ogles, and Collins, all signing on the document to begin impeachment proceedings for James Boasberg, Chief Judge out of D.C. And this is a good place to start. We have a lot of problematic judges out there, but I think you just need to haul one in front of Congress, and hopefully they'll get the hint and recognize that the Republicans are not just playing tiddlywinks just all day long and actually doing their constitutional duty, which is to oversee the judiciary, making sure they're acting in good behavior and not committing high crimes and misdemeanors. So Congress should be acting on this and checking them. It's their obligation. It's their duty. And if they're not doing it, maybe Judge Boasberg didn't know, then that's pathetic. It should be highly aggressive between the branches. We don't want them making excuses for each other. Go investigate them so that we have proper checks and balances. So here, Congress is getting started. Be it resolved that Boasberg be impeached for high crimes and misdemeanors, not just good behavior. Saying, all right, here it is resolved now in the House that Jeb Boasberg is impeached for high crimes and misdemeanors pursuant to these articles of impeachment that we will now send over to the Senate. So this just got introduced, going to need to vote on it, and then the Senate would vote on removal. Articles of impeachment exhibited by the House of Representatives is against James Boasberg, who is appointed to serve as the U.S. District Judge. And here is the first count, Article 1. Abuse of power. Ignoring his responsibility to wield the power of his office as a judge in a constitutional manner, Chief Judge Boasberg granted special counsel with an asterisk because he's illegitimate, John L. Smith, a.k.a. Not a Real Boy Jack, his authorization to issue frivolous non-disclosure orders in furtherance of an FBI investigation project called Arctic Frost that was created by the FBI, Tim Tebow, Walter Giardina, and others, and then Jack Smith took it and ran with it as a special counsel who was completely illegitimate. These non-disclosure orders covered members of Congress who were acting in accord with their legislative duties and their privileges guaranteed under the Constitution. Article 1, Section 6, Clause 1. Boasberg violated that. Chief Judge Boasberg authorized the issuance of frivolous non-disclosure orders covering at least, that we know of, Marsha Blackburn, Ted Cruz, Lindsey Graham, Bill Hagerty, Josh Hawley, Ron Johnson, Cynthia Loomis, Rick Scott, Dan Sullivan, Tommy Tuberville, and Mike Kelly, a representative. These illegitimate and frivolous non-disclosure orders and subpoenas, they threaten members of Congress by imposing undue legal scrutiny for fulfilling their constitutional duties. And Chief Judge Boasberg, who's supposed to be a neutral judge, he signed an order prohibiting AT&T from informing Senator Cruz of his subpoena for at least 1 year. Chief Judge Boasberg expressed that there were reasonable grounds to believe that such disclosure will result in the destruction of or the tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation. And how can a judge make that conclusion without knowing who the subject of this action is? They just said, well, it's a bad person. Oh, I guess I'll take your word for it. Judge Boasberg knew. He had no clear reasonable basis to make this finding about Cruz, which accused him of being willing to destroy evidence and to intimidate witnesses. How can he even write that without knowing who the person is? In violation of both the law and Senator Cruz's ethical obligations as a member of the bar. He's a lawyer. Lawyers for the Texas bar, I'm presuming, go through character and fitness. And he's a sitting senator. Now, the code, U.S. law, under 2 U.S. Code, section 6628, it says, the office of the Senate Sergeant at Arms, any officer or employee of the office of the SAA, or any provider for a Senate office that is providing services to or being used by the Senate office shall not be barred. So if you're working with the Senate or you have a cell phone through the Senate program, you shall not be barred through operation of any court order or any statutory provision from notifying the Senate office of any legal process seeking the disclosure of Senate data. You cannot not tell us if you're coming after our data. We have a right to know. They wrote it into the code, U.S. code. Anything that we do, if we're transmitting, processing, storing data, whatever, electronic systems maintained or operated, whatever, if you want that, you got to let us know you're coming for it. But Chief Judge Boasberg, he does not appreciate the basic statute and contributed to the legal inquiries that violated the law, indicating he can't serve as a chief judge. If he can't even read the law, which says that explicitly, then he's violating the law. It's unclear if Judge Boasberg facilitated the frivolous subpoenas issued by Jack Smith, which covered conservative nonprofit organizations, including but not limited to others. So did Boasberg sign all the other, 400 people who got hit with these? America First Policy Institute, Women for America, Center for Renewing America. Many of these same organizations had been outspoken in opposition to various Biden policies, and they all got attacked. It appears that these subpoenas were intended to silence political speech. All true. In addition, these frivolous subpoenas also covered activists and patriotic Americans, including Jeffrey Clark, shout out, John Eastman, shout out, Rudy, shout out, Ed Corrigan, who got attacked, Mark Meadows, Cleta Mitchell, Amy Creamer, Kelly Ward, Jenna Ellis, Wesley Denton, and many others got attacked. The weaponization of the judiciary compromises, and a lot of people are missing off this list, by the way. This is not inclusive. There's maybe 100 more. The weaponization of the judiciary compromises the separation of compromises. If you weaponize your position like Boasberg did, the separation of powers in the Constitution, and Boasberg's impropriety in participating in the undue investigation of members of Congress casts doubt on his ability to execute his office with good behavior. Wherefore, Boasberg is guilty of high crimes and misdemeanors and should be removed from his office immediately. We're happy to see those come through, and we'd like to see a little bit more fleshing out on the high crime and misdemeanor, what that is explicitly. But yeah, violating the provision of the code, it's a pretty good indicator that that's happening. So that got introduced. We see Byron Donald saying, "I proudly stand with Representative Brandon Gill in impeaching this radical activist judge. He abused his power by weaponizing the judiciary. He's committed high crimes and misdemeanors. He's unfit for office, and he should be impeached." Read the articles below. We already did, Byron. Thank you. He's also, we got this from Ted Cruz, says, "Thank you, Brandon Gill." He's in the Senate, so he can't do this. "For filing these articles. He signed off on secret subpoena for cell phone records of at least 9 Republicans, including me. Impeach this judge." From Cruz. Byron, a little bit more from him on his position here.
Which should be protected, but the Democrats didn't want that. They wanted everybody to move on. They wanted no examination of it. They wanted no ability to question it. And let's take a further step back. And what did they do with the results of the 2020 election? They put in a president of the United States who had no mental capability to do the job. And then lied to the American. They lied to you, the press. They lied to you guys time and time again. "Oh no, Joe Biden's fine. Everything's okay." You didn't see the man for 6 months, 8 months, 10 months. He wasn't holding cabinet meetings. He would come out, have 3 cards, and when he was done, they would usher him back off stage.
You answer this person this question. You turn around. You take a step off the stage. Constant. But the media likes to be lied to and abused, so they didn't care too much about that. They're like, we still love Joe as long as he's a Democrat.
It is one of the greatest affronts to our constitutional republic, a chief executive who was put into place who did not have the capabilities to do his job. You guys in the press watched it. We watched it here on Capitol Hill. But you want to talk about 2025?
Yeah, and they say, well, he had a stutter. Okay, so be nice to him. Don't make fun of his stutter.
There were irregularities. President Trump was well within his rights to question that. And he did, obviously. But that doesn't warrant a massive investigation. That does not warrant Jack Smith, a rogue prosecutor who, by the way, this is not the first time Jack Smith has done something like this. Go talk to former Governor Bob McDonnell of Virginia.
Ooh.
Because he did it to Bob McDonnell, too.
That's right.
And they turned that guy loose.
That.
Judge Boasberg was a part of it. Why? To go after their political rivals. And in my now 5 years later, to protect the ineptitude and the radicalism of Joe Biden's presidency. We don't even know if he was mentally with us the last 2 years. We don't know. You have his wife's right hand, Anthony Bernal, pleading the fifth in House depositions. You have his doctor pleading the fifth in House depositions. I was present for both of those. He's pleading the fifth. Does not want to answer the American people to the mental capabilities of President Biden. But when this issue comes up about the weaponization, which did occur, of the Department of Justice, going after their political rivals for the purposes of trying to win elections and maintain power, that's your story. Not whether President Trump challenged the results of the 2020 election, which, to be blunt, he had every right to do, and there were major irregularities in that election.
Nicely done, Byron Donalds, explaining the president was lawfully within his prerogative to question things as he did, and they attacked him for that in the aftermath. And so here you can see we've got more. The judges are out of control, and we covered this case some time ago, but we're happy to see Congress now stepping up. But today, Grassley and Jordan sent a letter over to the Chief Justice of the Supreme Court, Honorable John Roberts, getting a letter courtesy of Chuck Grassley in the Senate and Jim Jordan in the House, both of them running the judiciary committees. And they say, hey, Chief Justice Roberts of the Supreme Court, you got a big problem here. We write to you in your capacity as the presiding officer of the Judicial Conference and the Chief Justice of the United States. If you remember, and we talked about this, on October 11th, the New York Times came out with a stupid article, and we read it, called Federal Judges, Warning of Judicial Crisis, Fault the Supreme Court and Their Emergency Orders. Okay, so federal judges talking to the press, talking garbage against the Supreme Court. Completely unbelievable, but they did it. The article reports that they said dozens of sitting federal judges, shared with the Times their concerns about risks to the court's legitimacy as the Supreme Court is releasing opaque orders about the Trump administration policies. Completely ridiculous for the judges to be talking out of turn. According to the reporting, the Times, the media, they contacted more than 400 of the almost 1,500 judges, and they asked them to respond to a questionnaire. Can you moron judges just fill out this form? Bunch of them like, yeah, sure. About the use of the emergency docket by the Supreme Court. Then the Times specifically included all the judges from districts that have handled at least one legal challenge in a major piece about Mr. Trump's agenda. Of the 400 judges that the Times contacted, 65 of them responded to the survey, and 47 of the responses indicated that the Supreme Court had been mishandling its emergency docket since Trump came back. Okay, all 45 of those, 65 of they should all be impeached. In my interviews, the Times said, in interviews, federal judges called the Supreme Court's emergency orders mystical, overly blunt. Someone said incredibly demoralizing and troubling, all talking like cowards who won't even reveal their names. They've all handled Trump cases. They're all coming out and explaining how biased and partisan they actually are, and they're all hiding under cover because they're cowards who are living in the gutter. They said this is a slap in the face to the district courts. One judge whined. One judge compared their district's current relationship with the Supreme Court to a war zone. Another said the courts were in the midst of a judicial crisis. And judges and lawyers have a duty of, candor to the court, and you have, to follow protocol. And they're not doing that. They're talking to the press about their own decisions and their disagreement with the Supreme Court. They can write it in an opinion and the Supreme Court can respond to it, but they're talking to the media because they want to create a counter narrative to the Supreme Court, which is their boss. It's really reprehensible. The Times explained that the judges responded to the questionnaire and spoke in interviews on condition of anonymity because they're cowards. So all of them. So they could share their views candidly, as lower court judges are governed by a complex set of rules. Yeah. And it includes specific limitations on their public statements. So this shows their complicity in violating rules that they know exist. Oh, I can't talk to you. If I do, I'm going to violate all my ethical obligations as a judge. Can I do it anonymously so I can violate my ethical obligations as a judge? Oh, sure. Great. I'm happy to do it. The Times went on to characterize these responses and interviews as overwhelmingly critical of the Supreme Court and reflective of extraordinary tensions within the judiciary. Man, federal judges have made other recent public and anonymous statements to the press criticizing the Supreme Court. In fact, on September 4th, NBC News published an article entitled, "In Rare Interviews, Federal Judges Criticize the Supreme Court's Handling of the Trump Cases." The reporting says that 12 federal judges, who we called out, gave anonymous interviews, and 10 of them said that the Supreme Court needs to explain its rulings better, okay? It should be impeached and fired immediately. One judge reportedly described the Supreme Court's conduct as inexcusable. 4 of them said that you, John Roberts, should do more to defend the courts. And one said the Supreme Court is effectively assisting the Trump administration in undermining the lower courts. You cannot believe that any of these people are going to be fair and impartial or run according to the rules set by the Supreme Court, follow the precedent. They are no longer qualified to be judges because they know that there are rules that prevent them from talking about this, and they're doing it anyways. Very bad behavior. The Supreme Court should investigate who these people were and sanction them. As the chairman of the committees on the judiciary in the United States, Senate, and House, we preside over the congressional committees with legislative oversight and jurisdiction over the federal courts. And we are deeply concerned that these public attacks on the court from sitting federal judges damages public faith and confidence in our judicial system. When judges call into question the legitimacy of their own branch of government, they erode faith in the institution itself. We're also concerned that the conduct of these judges, as reported, may violate their ethical rules. Canon 1 of the Code of Conduct for these hack judges states that they should follow this. A judge should uphold the integrity and the independence of the judiciary, and a judge should act at all times in a manner that promotes public confidence in the integrity and the impartiality of the judiciary, okay? Judicial Code of Conduct says you can't get out there and talk garbage about the courts because the court's power relies on our integrity and our legitimacy and our credibility. Do you agree? Yeah. You swear an oath? Yeah. Great. You can be a judge. And another canon says a judge should not make public comment on the merits of a matter pending or impending in any court. And what's also so scandalous about this is these cowardly judges won't even reveal themselves. So the Trump administration could notice them and say, oh, you have to disqualify you. Okay, you're obviously out there talking crap to the media, saying the Supreme Court's biased and more. So you can't hear this case where the Trump administration is a party. You're biased, you're partisan, you talk to the press. It's okay, maybe you can do that, but now you have to reveal yourself so we can get you off of our case. They won't do it because they're acting like little moles who are embedded in the judiciary, executing the coup from inside. Chief Judge Diaz of the U.S. Court of Appeals for the Fourth Circuit could consider these canons. We covered this. There was another judge called Michael Ponzer, okay? He at least wrote a public article. He wrote an essay. He said, a federal judge wonders, he was a sitting judge, how could Alito have been so foolish? Writes an article. At least he put his name on it. Not a coward like the rest of them. He was in trouble. They said, you can't talk crap about Judge Alito in a New York Times piece, Michael. The judge concluded that his statements expressed personal opinions on controversial public issues, criticized the ethics of a sitting Supreme Court justice. It violated the code of conduct. You can't do that. He also concluded that it would be reasonable for a member of the public to perceive the essay as commentary on partisan issues as a call for Alito's recusal, also in violation of the canons. Now, the reasoning in that prior ruling in resolving the 2024 complaint appears to apply to these same statements from these anonymous judges. Anonymous public comments from sitting judges describing the relationship as a war zone, accusing SCOTUS of undermining the lower courts, or otherwise impugning the legitimacy of the Supreme Court rulings violates the code of conduct, violates judicial canon. Additionally, because of the timing of these comments and the substantial coverage around this litigation involving the Trump administration, it would be very reasonable for a member of the public to view these statements as commenting on partisan issues and ongoing litigation, which they all were. So, John Roberts, listen, in light of these concerns, we urge you to consider the appropriateness of these public yet anonymous comments and whether they breach the ethical obligations of federal judges. While we do not know the full extent of the comments or who the judges are, because they're cowards, we remain convinced that judges should not be going to the press to undermine and denigrate the Supreme Court and hide their partisan bias when the Trump cases appear in their courts. Additionally, to provide us with information, John, it'd be helpful if you did this. Does the Judicial Conference agree that making anonymous public comments to the press undermines public confidence? And has the Judicial Conference or any other branch authority cautioned or informed judges about that? Has guidance been provided to the federal judiciary about the conduct of these judges? If not, does the judicial branch want to give some guidance about anonymous messages to the media? And does the judicial branch plan to investigate or address this in any way? If so, when and how? Thank you for your attention to this matter. Signed by Chuck Grassley and Jim Jordan. And of course, we'll see what John Roberts does. He may not do anything, just put this in the shredder with the rest of them. But this is pathetic. These judges should be ashamed of themselves. I think they are ashamed of themselves, which is why they hide in the gutter and lob attacks in violation of their judicial canons. If they're going to violate these judicial canons, what else are they violating? We know already, all of them. And they don't have the stones to come out and write an article like Michael Posner did. At least he would do that. Instead, they'll just slam their own bosses from the sidelines because they're too dense to actually address it in their opinions. And we're under attack. Remember, one of the judges said, the Supreme Court doesn't have our back. I'm like, oh gosh, which one is that? Which one of the judges is saying that? They're all babies and they're cowards to boot, and they know it. So here is Grassley, who is talking about his investigation. He just sent a letter over to John Roberts. He sent a letter to Verizon. Here's what he had to say about all this on with Newsmax.
Who's been dogged in rooting out covered that we're being surveilled. I was minding my business.
Now we know it was a fishing expedition to go after Republican organizations, people connected to Republicans, people that are conservative, even Charlie Kirk's organization, TPUSA, was involved with this. So it was very much a fishing expedition, and I think that they were spreading a wide net because they were looking for anything they could to hook on Trump, put Trump in prison, keep him from running for president, and things of that nature. But Jack Frost subpoenaed all this stuff, and thank God the whistleblowers told us about it, gave us the documents, and that's why your name came out.
Yeah, okay. Well, I'm looking forward to reaching out to you off the air. Maybe we can have a meeting so I can find out the emails and whatever else is going on, because I want to find out more, not just about me, but the president. Let's look.
All right, so Chuck Grassley is out there. Jack Frost, Jack Smith, same difference. We all know what a scumbag is. So Congress now moving forward, articles of impeachment filed, letters to John Roberts sent saying, John, get control of your maniac judges, okay? They're talking to the press like cowardly, pathetic Democrats, and you need to get control of your House. So we'll keep our eye on this one, my friends, and encourage it along. We need accountability in the judiciary because they're in the middle of a judicial coup, and it cannot be allowed to happen. Thank you for subscribing and joining as we keep our eye on this one. All right, my beautiful friends. What an amazing stream it has been. If you're just joining us, quick recap. We talked about Lindsay Halligan And her fight for survival, really, we'll see what the judge does with this. I mean, she should be good to go, but she submitted a reply in the case of James Comey and Letitia James, who are both being indicted out of her district, the Eastern District of Virginia. And so we got a nice response from her explaining how her appointment is perfectly valid. She's not like Jack Smith. It's not a made up special counsel conglomerate of statutes. There's clear statutory authority and prior precedent that makes her validly appointed and capable of bringing these cases. We read through that, a little heavy lifting on that one because of the legalese inside, but we got some good nuggets out of there, and we'll wait for the judge's ruling. We also then talked about new disclosures from Pam Bondi, who says officially now from the DOJ's perch that Trump's personal phone records were also gobbled up by Jack Smith. We saw Kash Patel also had his records gobbled up, FBI. So between Dan Bongino, Kash Patel, and Pam Bondi, you'd think there's going to be enough effort to actually indict some of these people, in addition to James Comey. So hopefully that's coming soon. But we went through that. We got some reaction from Caroline Levitt, Rick Scott. He sent a letter over to Verizon. He's not happy about this. He says, hey, Daniel Schulman, why did AT&T refuse to give these records over? Because they actually followed the law and you didn't. Care to explain yourself, sir? Jim Jordan, opening up a probe, sent another letter over to Verizon as well. So we'll see what Verizon has to say about that. But everybody involved in that release should be held accountable, including all the goons on Jack Smith's team. Then finally, we looked at the articles of impeachment that have been filed against the judge who approved those subpoenas from Jack Smith. Of course, James Boasberg, the same guy who's been attacking the president's official policies from his District of Columbia bench. He's now in hot water. A lot of people calling for him to be impeached and to be deposed, hauled in front of Congress to answer questions. Chuck Grassley also sent a letter speaking about bad judges to Chief Justice of the Supreme Court of the United States, John Roberts, demanding some answers about these hack judges who are running their mouths to the media, won't even use their names to do it, so that they can continue to act in partisan and disgusting fashion. I would like to know their names. All of them. And maybe the time something will happen, we'll get the list. But that's the coverage today, my friends. And now it's time to hear from you. And thank you for being here. Thanks for joining us. Thanks for becoming membos and supporting our work, for subscribing to our channel, for inviting everybody you've ever met in your entire life to come and join us when we go live. And we got some great comments in the house. What's up, Donut? John, thank you for linking these ones in. We do have some new membos joining us. Woo, what a beautiful day it is. Yep, here it is, Jack Smith Pinocchio. Good way to start the show. From Jack's, I think that's a real photo, pretty sure. Not positive, but it looks real to me. DCFFKS Tarpon Springs Police for Cases. Welcome aboard. Well, this doesn't make any sense. Became a supporter, but also been a membo for 26 months. Thank you for being a membo for 26 months. That's coming up on 3 babies. Love your show, Rob. Salty tears are lovely. Yeah, there's a lot of tears going on out there today. Yeah, good to see you. Tarpon Springs Police for Cases. Nice to have you here. Thanks for being here for 26 months. You're amazing. Hey, I'd rather be skiing. 20 new membos coming in from I'd Rather Be Skiing. New membo friends, we'll see you in a bit on the after party. Come and join us. Keith Bradbury. Fallen Hero is here. Gary Owen. Matthew Bushcraft. We got Blue Curtain Burner. Music Mountain Girl is here. Soupy. Kathy Isaac. What's up, Tracy Collins? Steve and Mindy in the house. Andrew Hunter. What's up, Molly? New Yorker. Mill Spec Hoagie. We got Hall Barrett. Garrett Pace. What's up, Jody Plocker? Alyssa Lear. Colleen K. and Catherine. All gifted membos courtesy of I'd Rather Be Skiing. Welcome aboard, new friends. We'll see you in the members only after party. And we talked about some good stuff this morning about the election fallout and the Supreme Court tariff case. This one from Spuds says hard times create strong men create good times create white liberal women create hard times. And that, I think, is like an ancient proverb. I think the Chinese invented that like 5,000 years ago. Rings true to this day. VWC class of 05. Welcome. Nice to have you, class of '05, in the house. Thank you for joining. Is here. Looks like an M&M. M&M. 5 membos coming in. Bob Taylor, what's up? Diana JT, same initials as DJT. Wow, that's awesome, Diana. You lucky dog. Luis is here. Pablo Aki, welcome. Robin Gelson, gifted membos, courtesy of MM in the house. Charles Beck, what's up? I think Mamdani's citizenship should be revoked and immediately deported. You know, it's not a bad idea. I mean, you'd make a martyr out of him, obviously, but it's like, do we let these communists take hold? The point is, he, I think, was fraudulent on his naturalization forms. Okay, he's not born here, born in Uganda, came here, said, I'm not a communist. I like capitalism. I'm not going to, bring in conflicting ideologies that are going to be at odds with America. Signed all of it and then lied about it and ran. So why would anybody else who is committing fraud on government forms, why would they be held accountable and Mamdani not? FD man. Bill Slick Willie Clinton said, it depends on what the meaning of the word is during his grand jury testimony in 1998. Yeah, and then did the thing on the dress. Yeah, he did say that. Depends on what the meaning of the word is. And everybody's, oh gosh, these friggin' politicians, right? Pritchie, 20 months as a membo. I hate the way America is going with New York. As if America falls, the world falls. Hopefully it's a wake-up call. Let the kids touch the stove thing. Yeah, I think it may be a wake-up call, in more ways than one. It's like maybe Kami Mamdani implements his communist policies. There's capital flight. The city starts to wake up to his false promises and pretenses and realizes this whole thing is just a sham. In many ways, like Obama did. He came in. The seas are going to stop rising. We're going to cure cancer. None of that happened. Okay, thanks, Obama. So a lot of the luster kind of fell off there. But ultimately, also, it might, instigate a response from the right that, hey, maybe we should be talking more about the issues that matter here domestically in America rather than whatever else is going on around the world. So, in other words, might help reorient the Republican Party before the midterms. Better to have a course correction now than in 2026. All day. Take it all day. Beautifully inappropriate. What's up? Hey, welcome. Thanks for being here for 20 months. Thank you for the gifted membership. Awesome folk. What a nice thing to say. Have you been getting gifted membos for 20 months? Man, that's a nice continuation there. Thank you, beautifully inappropriate, for being here. What's up, FD man? Yeah, it does depend on what the meaning of is, indeed. FD man, thanks for the dono. John McGarvey. Rob, I have become incensed that we are being distracted from the fact that Chuck Grassley is obstructing justice. This stupid blue slip thing is akin to letting the criminals pick the police. We currently have 15 of the 50 federal prosecutors. If Chuck can't do his constitutional duty, it's time to remove him and replace him with someone that will. So Chuck Grassley's a senator, right? So you're saying maybe primary Chuck? Yeah, so the blue slip thing is that you can't appoint, in other words, Grassley is not letting Trump's nominations go through if Democrat senators from blue states don't sign off on that U.S. attorney. There's like this honor code in the Senate that, like, if Alina Abba wants to go be appointed in New Jersey, she's got to go get permission from both of those blue senators in New Jersey before Grassley will allow her to move out of committee to get a full vote. And the question, of course, is why is Chuck honoring that and delaying the appointment of very important people? Yeah, it's a good question. Chuck Grassley, man, we really appreciate his work. I was thinking about this. Like, I have my concerns. Who's going to take the helm when Chuck Grassley's gone? Like with these whistleblowers, like he's been on Arctic Frost for years. Ron Johnson's right there in the wings, but yeah. I do agree. It is time for the Republicans to start playing like for keeps because they haven't not been doing that. DM Walker, Troublemaker Jonah, welcome aboard. Newest supporters, we'll see you in the after party. Grab the members only stream from this morning. Yeah, Wendy says, 19 months as a membo, 2 babies, and I need a break, LOL. Well, that's too bad. There are no breaks here on this train, okay? We just keep going. You're going to be all right. You got another couple in you. You're going to be okay. Thanks for being here, Wendy Ty. I understand what you mean. Sometimes a break is necessary. Unfortunately, I can't take a break for myself, which is a problem. Dark Road. I want to say that I'm so excited that Pam Bondi is handing over documents to Congress of Smith spying on Trump's phone, so they can send a strongly worded letter about it. I know, it's like, Pam, do you know that you're the Attorney General of the United States? There's a lot of power that you have. You don't have to just send emails. Hey guys, look what else I discovered. You can do something about it. Dang it. Good to see you, Dark Rogue. I know, I read it. I'm like, ugh. Thanks, Pam. FD Man. The blue people seem to give more deference to Article 3 blue judges as high priests in their temple of baby sacrifice, anti-constitutional truths with a big FU attitude. Just sucking off the blood of America. It's just true, FD Man. Yeah, well, the judges really can do a lot of the things that they wish they could do just by fiat. Well, this is equitable, or this is democracy, or this is fascism. They just say it, and with the stroke of a pen, they can do whatever they want, run the country. Just like the communists want. Dark Rogue says, I wonder if the nuclear option can be used for the Boasberg impeachment. If so, thank you again, Harry Reid. I don't think so. Yeah, I don't think so. I think the nuclear option would relate back to Senate created procedures. So the Constitution says that the houses can set their own rules, but the Constitution does have some specific limitations on impeachment. So passing bills governed by the House rules and the Senate rules, which they set for themselves, but impeachment has constitutional requirements inside. So it's a good idea, but I don't think they could. Lilu, multipass. Hey, do you know what came from the meeting this morning that Trump had with Republicans about the filibuster? No, we don't. He flew down. We covered a little bit of that this morning. We had a clip. But then Trump flew down to Florida, I think Miami, and gave another talk. So, and do you know what it would take or how long to do that? So I think quickly. Yeah, I mean, if they had the wherewithal to do it, I think the process is that they basically would try to invoke cloture to end debate. That would get denied. Then they could appeal that. And in the appellate process, and again, I'm not a congressional procedure expertologist, but then they would appeal that, and the appeal could be resolved with just a simple majority vote. So the question I had is, what, do you need 60 votes to end the filibuster, to nuke the filibuster? Not really. There's a mechanism by which you would object and appeal a ruling, appeal the decision to not invoke cloture to keep the debate open. And then in that appellate process, there's a mechanism by which you could then rewrite the rules essentially with just a simple majority vote. They call that the nuclear option. So, and it might involve bringing in J.D. Vance and others to do it. But that being said, you'd still need 51 senators to get it through. And I'm not sure you have those anyways. You've got Graham, you've got Murkowski, you've got Collins, you've got a bunch of squishy Republicans. I'm not sure how Rand Paul would come down on some of those things, but again, I don't know that it's a good option. I think ending the filibuster, if the Republicans acted like Trump and they got a bunch of stuff done and they were values aligned, then maybe you do that and just cram a bunch of stuff through and try to deprive the Democrats of any opportunity with voter ID and election reform, all these things. My question is, would they comply with that anyways? And if the Democrats did come back in power, then they would just reverse everything with a simple majority vote. Unless the Republicans change the rules, pass a bunch of stuff and change the rules back. But then the Democrats, if they took control, would just do the same thing. So anything the Republicans could do, the Democrats could undo. And the Democrats come to play, okay? They bring knives and bats and guns and shoot people in the neck. The Republicans are playing tiddlywinks and thumb wrestling with each other over there, over spending for other countries. Chubby, what's up? Congress needs to reassign all the current judges against the administration. Should be grounds enough from just the article and their anonymity. No one stepping forward, all get changed. Interesting, yeah. So it's if you don't admit who took that out of the refrigerator, the whole team is doing laps. Everybody. You can tell me who did it or you're all running laps. Everybody's like, okay, I guess we're all running. Kind of a thing. Lilu, thank you, Chubby. Now that Zoran is in, can you please find out if he can make Sharia law legal, please? So not simply, right? So he's just the mayor. He's not the dictator of New York, not yet. So he has a lot of power. I think the New York City mayor's office is, it's like their city budget's like $100 billion or $120 billion. I mean, it's massive, massive. And he has a lot of power. I mean, he can appoint commissioners. He's got say, I think, in, how education goes, like a lot of the city services he is powerful in. He'll have, city councils and other commissions that he's working with, but he'll have a lot of power, but he won't have the power to unilaterally just come in and say, everybody's now praying 5 times a day and you're all wearing burqas. So enjoy it. There's still a lot of power that he doesn't have. And so I'm not worried about Sharia law yet. Not yet. Hey, Paul M. There is no mention of impeachment in Article 3, only removal for not serving during times of good behavior. Article 2 creates the inferior courts. So removal from... So is this a response to the filibuster question? So I would still say that there are rules in the Constitution about removal, and there are rules in the Constitution about houses creating other procedural rules for how they pass legislation. From Paul M. God bless America. Welcome aboard. Jonathan F. Welcome aboard. Great to have you both. We'll see you in the after party coming up. The Rubos are here. Man, we got an extension of the Rubos Salt Shop promo, baby. Head over to rubossaltshop.com. They make the best salt that comes from the bottom of the ocean. You can use code WTW35 and you're going to save 35% off their entire pack. It's really good stuff. We use it all the time. Perfect for holidays. 35% off. It's hand harvested from the coast of France. What kind of salt are you consuming right now? Does it come from the ocean at the bottom of the ocean in France? Mine does. I know. So get your Rubo salt, man, and be sophisticated like we are. It's the secret ingredient that transforms ordinary meals into unforgettable culinary experiences. And if you're using Morton's, get some Rubos Salt Shop. Thank you, Rubos. Thanks for the discount. And sorry for my condescension about salt. WTW 35 in the House. Terry Garrett. Does the Senate need a majority to impeach Jeb? So, yeah, so it's, I believe 2/3 for removal, right? So he would get impeached in the House. And if you want to remove him, then it's 2/3 in the Senate. So there are rules about removal of somebody from a position of office. So, yeah, so he probably would not get removed because there's not 66 votes in the Senate to do it. Doggone it says he might be a martyr, but he'll be a deported martyr and he'll be gone. They can martyr him back from Uganda. Yeah, it's a good point, doggone it. Nurse D. Hey, appreciate your readings, Rob. Thank you, Nurse D. Thanks for being here for 4 months, almost halfway to a baby. Great to have you here. We got Bruce Rice. I will not donate 1 red cent to New York for 9/11 ever again. They forgot. So shall I. Well, we'll remember, the amazing men and women we lost that day. Horrific. I can't even imagine. But yeah, New York, apparently, they've got an answer. They got a solution for all their problems. It's more government. It's Mamdani. So enjoy it. James Frederick. What's up? Welcome aboard as the newest supporter in the House from James Frederick. B.H. Williams says, parliamentarian. Parliamentarian is the word. April Maid, what's up? Has there ever been a response to these letters? Yeah, actually, we did read. I know it's a funny comment. You're probably saying some of that in jest, but yeah, we did read responses from Verizon and AT&T. They're getting more letters because Verizon's response was very unsatisfactory, and AT&T explained they didn't give any documents up. So AT&T really made Verizon look like a bunch of jerks over there. B.H. Williams, if you were to ask me who I'm mad at, I'm always mad at Democrats because they're idiots. But right now, if I was polled, I'm angriest at the congressional Republicans for being bigger idiots than the Democrats, from B.H. Williams. Yeah, and maybe that sentiment is responsible for some of the election results that we saw yesterday. People are wondering, what are the Republicans actually doing? Aside from delivering tangible benefits for their constituents. Still hard to really figure that out. Hey, B. Torn. Yeah, says 3 Trump appointments have been ruled ineligible. Alina Abba, Bill Esseley, and others. Where was their vigorous defense? I know Bondi was too busy with that Epstein file crap to find out in real time to respond to it. Yeah, I don't know, man. And I'll tell you, if Lindsay Halligan is disqualified because Pam Bondi couldn't appoint her appropriately, that's going to be disqualifying, like immediately. Troublemaker Jonah, why do you assume that Verizon had anyone other than Indians overseas answering the subpoenas? Good question. Just like their customer service. It could be true. It just could be some Indian person who's over there. Just like, oh, I don't know, Ted Cruz. Yeah, sure, no problem here. Although he was AT&T. Marsha Blackburn, yes, from a judge, signs off on it. Thank you, and that's it. That's the close of business. Hiker dude, wouldn't deporting Mom Donnie, or what was the one we saw? Moron Donnie, I think was this morning we saw something. Why isn't Moron Donnie picked up? So maybe we'll try that. Set a wonderful precedence for the rest of the illegal aliens. Yeah, well, I think the standard has been if you can get past the post, like as long as you sign your immigration documents and they say, oh, here you go, you're a citizen, then you can be like, oh, perfect. Now I can be honest. And now I can tell you the truth about what I believe, even though I signed those documents under penalty of perjury that I did not think those things. And if you commit fraud on anything, if you lie on your mortgage documents, you get charged with crimes. So how is that any different than lying on your naturalization documents? Doesn't make any sense to me. But my friends, what a beautiful day and an amazing stream it has been. Very nice to have you here. FD Man, thank you for this comment, which we won't read, but thank you for sending the dono in. We appreciate that. But my friends, it has been a beautiful day and an amazing stream. Very glad that you're here and with us. Thanks for going through the news with us. Thanks for subscribing to our channel before you get out of here. Thanks for liking the video. If your fingers work, if your thumbs work, if they don't, I understand. But there's other options like your forehead or your knee for hitting that button. We appreciate it. But we'll leave it here on the day. Before we wrap it up and go over to our members only after party, I want to say thanks to our amazing mods and meme smiths. Big thank yous out to Donut, to John, to K-Bean, to Carrie B, to Muffin Rando, Neuro D, Janek, Dog Digger, Geegum Geegum, Just Rhonda, and Elliot, all modding the fort down for us, keeping things nice and orderly around here. We appreciate you. And of course, we will be back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. We'll see you right back here tomorrow. Until then, be well and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news.